Any mention?
Your Lordship, is one partnered matters, Your Lordship. Item number 17.
One upgraded.
So, Your Lordship, let's be in the second half, Your Lordship. I'll be having some problem at the moment.
Arun Kumar Tiwari?
Yes.
No.
The second half, Your Lordship.
Part heard. Already your lordship only wanted to confirm that whether respond number 7 and 8.
I don't remember anything, Mr. Machanda. I don't have memory like yours.
Well, it's already part heard. Only that confirmation he has given on the last.
When you have other case in Shillong? When you coming again for your other matters?
Today I've got some matters.
No, today you have some matters, of course, but for this matter, when you coming back? You have it on that day? Second half of Mr. Devnath, I don't know what second half means. You might come at 4 o'clock. You fix a date, we'll give it. Yes.
After 2 weeks, my lord.
2 weeks. Okay. Yes.
Next day he should assure, my lord, because of the last three occasions he has
That's
taken.
between councils to, to extract that consent. Yes.
He has not informed also.
You pay his lunch and conveyance fees, conveyance money.
That's it.
Okay. Yes. Yes.
Lord, I'd like to mention item number 22 and 23, my lordship.
20?
22 and 23, my lord.
I can't hear.
22 and 23, my lord.
22 and 23.
Yes, your lordship.
What's the matter about?
This matter regards to the suspension of school teachers, my lord.
It's not been heard before.
It was heard, Your Lordship, for a few.
For 2 minutes.
Yes.
When?
No, your lordship. Pardon?
When?
After 1 week, your lordship.
It will be after 2 weeks, Your Lordship.
2 weeks.
2 weeks, Your Lordship.
Yes.
Oblige, Your Lordship.
Duly obliged.
The request of so.
May I please be your lordship? I would like to mention item number 19. The conducting counsel, Senior Advocate S.P. Mahanta, is indisposed. I would humbly like to pray for 3 weeks.
Yes, sir, 19. As a senior counsel for this funds in the sports matter of 3 weeks. Yes. You inform the other side? No. You inform them.
Lordship, I'm for the petitioner, my lordship.
You are the petitioner?
Yes.
I'd like to mention item 16, my lord.
16? Why are you mentioning
Have
it?
it day after tomorrow, my lord. I'm still, my lord, to this particular facts of the case, well, I've got certain judgment, my lord. Of course, the facts are not fitting. My lord, just a day's indulgence, my lord. Day after tomorrow, my lord.
Facts are fitting to the judgment.
Fitting to this
Or the
particular
judgment
case.
is fitting to your facts.
There are,
Okay, I'll give you one chance.
my lord,
Public law remedy, interesting
Public law
case, yes. Day after, as a fixed matter.
as a fix.
No more further adjournments. Yes.
But, I also back to make a mention of one unlisted miss case, my lord, which we have filed in a matter which is listed tomorrow, my lord.
Maybe they'll come tomorrow.
Obliged.
Main list item number 1.
Where's the additional affidavit?
Your lordship, I'm the petitioner, your lordship. We are supposed to file the additional affidavit.
Not you?
Yes, your lordship.
Your lordship, we're the
petitioner.
petitioner.
Supposed to file.
Oh yes, what happened?
Your lordship, we've received a copy. We are, however, seeking a week's time, your lordship, to file the same.
MS Esrum Thao, whether Mr. Praise funds allowed further 1 week time to file the additional affidavit being record order dated 11/4/2023. List thereafter. And so.
Item number 2.
Yes, Lordship. This respective respondent yet to file the affidavit, Lordship. Yes, just waiting.
Which one? Respond number? One second. Who's 8 and 9?
I'm for the 8, Your Lordship. They may be allowed sometime.
8. You're not filing affidavit also. Why?
I'm for the 8, Your Lordship, as per.
You're for 8 or 9?
This is 9 then.
Make up your mind.
You'll see with this 8 it was last time say. There was some changes.
Okay, whatever it is, how much further time? This matter is pending from 21. Anyway, yes. Further 2 weeks time is granted to the respondents, to the advocates, respondents 8 and 9 to file affidavit. Stop next one. What about rejoinder to 1, 2, 4, 6 and 7?
Because it will be good if they fight it together so that I can compare, because
Yes,
now
next PT Summers submits the rejoinder will be filed to all affidavits once the affidavits of respondent 8 and 9 are on board. At least the matter for 2 weeks, yes.
3? 3?
3 is also same project, same code area of nationality. It's connected with number 2.
You are appearing for whom? GHDC.
Your Lordship, I'm for the national.
Item number 3. Okay.
In 3 there is no GHDC.
but respondent number 7 not.
You are not file affidavits here at all.
For state respondents, I require 1 or 2 days.
What about you are appearing for? And MSCB Savya?
For respondent number in this item number 3 for respondent number 7 and item number 2 respondent number 2.
No, in item number 3.
7.
You are not file affidavit also. Why?
My lord, the difficulty with this was that we have already made an offer to the petitioner, my lord.
What offer?
My lord, offer, my lord, for the land
I have not received any communication.
refused to accept, my lord.
Later,
Why you refusing to accept?
Your Lordship, I have no knowledge regarding any offer. What offer they have
That means you have no instructions from your
No
client.
instruction. No instruction.
So
Let
be
them
careful
find
that
out
you don't accept the compensation and you'll still be doing the case here.
No, Your Lordship, that is not the case, because she is just making a verbal submission. There is nothing instruction from my client. Neither they have given. Let them file the
File
affidavit
affidavit.
indicating all this. What they
MSR
offer.
only GA for respond 1 and 4 submits that though offer of compensation has been made to the petitioner, the same has been declined. However, the same has not been substantiated by any materials that have been brought before the court. Stop as such is directed to file an affidavit bringing the same on record, apart from other facts. Stop. Then Mr. Devnath 5.
Further, I'm 6. I have to file, Your Lordship.
Mr. R. Devnath number 5.
6.
Oh no, sorry. Number S. Rumthau number 5. S. Rumthau for 5. Mr. Devnath for 6. MSC CB Sawan for 7. Pray for and allowed further 2 weeks time of an affidavit just thereafter.
Item number 4.
This newly implemented.
One
Justice
second.
support 5.
Let the file come.
Humbly take time for another 2 weeks, Your Honor, as we are newly implemented for this matter.
Mr. Abraham,
File
file.
5 and 6.
You are for whom? You filed. Right. You newly implemented. MS. 5 and 6. Really, and in behalf of respondent 5 and 6, place funds allowed. On behalf of newly implemented respondent 5 and 6, place funds allowed 3 weeks time to file. 4 weeks time to file affidavit. Stop. Mr. H. Abraham submits that as their formal parties, no effort be forthcoming from their side. Stop. MS Pasanthev. On behalf of respondent 5 and 6, submits that has already been filed. Only it's a matter of 3 weeks for affidavits by respondents number 5 and 6. Yes.
First,
5. Item number 5.
In this, I'm just given 3 days time. Everything is ready, but I have to read you again one annex. Only 3 days time. I'll be fine by Wednesday, Your Lordship.
Why?
5, 6, and 7. In item number 5.
When did you enter appearance? 13/4. Now it's 13/6. Well, now it's 19/6. 2 months. Stop. Mr. H. Abraham submits affidavit ready and be filed within 3 weeks. Stop. However, Mr. S. A. Sheikh prays that he may begin 2 weeks' time. 3 weeks further time for affidavit. Prayer allowed this after 3 weeks.
Item 6.
1 second. Please let the file come before the court. Same petitioner.
Yes, Lordship. Lordship, same petitioner.
I am for 5 and 6.
Lordship, I'm appearing on behalf of Respondent 124. Correspondent
Yes.
on behalf of A.H.
Karwanlang.
Karwanlang, yes.
Don't know his name? Okay, yes. Further 3 weeks' time granted to respondents to file respective affidavits just thereafter.
Item 7.
Waiting for 2 weeks' time to find my reply.
We'll ask for personal appearance.
What do we have not received any instructions from
We'll
him.
ask for personal appearance then. Or you want a bailable warrant of arrest?
But,
You take your pick out of the two.
in both the options, my lord, my heads are dangling, my lord.
Lawyers' hands are never tied.
My lord, only 2 weeks indulgence, my lord. In the meantime, we'll try and have a contact with him, my lord, and seek instructions in this regard, my lord.
So this matter has been filed since? When was it filed?
It was filed May, my lord. 2nd of May
Filed on
23.
2nd May 23, and the private respondent and the respondent entered appearance on 5
appearance on
5th of May 2023.
2nd of May only.
2nd of May 2023. However, till date, no affidavit been forthcoming to answer the charges as made out in the contempt application. Stop. Next paragraph. Today, Mr. Estapa prays for further 2 weeks' time to file the affidavit. Stop. It is made clear that this indulgence is given its last opportunity, during which the respondent will have to appear in person before this court
One
on
small
the next day.
correction. One small correction. This matter was first moved on the 11th of April, not on 2nd.
File on 11th April, and there is also a list also for affidavit.
Item number 8.
Lordship, I filed my affidavit in this for both the respondents.
Yes, Your Lordship. May I please, Your Lordship? I humbly pray I needed 2 weeks to file the rejoinder.
Yes, Ms. Angaji, on behalf of the petitioner, prays for 2 weeks' time to file rejoinder affidavit to the affidavit filed by the respondents. Yes.
9.
Please, Your Lordship. Your Lordship, rejoinder is almost ready, Your Lordship. I'm praying for 1 week time, Your Lordship, to file.
This regarding that excommunication?
Yes, Your Lordship. No, social boycott, Your Lordship.
Social boycott. Mr. Dinyota prays for a lot further. How much time?
1 week.
It's 1 week time to file affidavit, rejoin affidavit. Just thereafter and so on. So.
All right, Your Lordship.
Item number 10.
Lordship, in 10 also we filed for the state respondents, we filed the affidavit.
We have
10
also
and
received
11.
the same. I'm praying for 3 weeks' time, Lordship, to file the rejoinder, Lordship.
You're not taking master role?
No, Lordship.
You won't take. Yes. So now pure praise for allowed for 3 weeks time to file rejoinder affidavit. Just thereafter.
Similar prayer for item 11.
11 also, Lordship.
Obliged.
Lumlang.
Yes.
Non-sage.
Yes. Right.
Elijah.
Obliged.
12.
Your Lordship, I'm entering appearance for respondent number 2. I have just filed my power today, Your Lordship.
Yes, sir. What's the matter about? Limitation? No.
That the rent deposit, my lord.
Oh, yes.
Regarding
You are paying for which part?
For the private
For the
You're
landlord.
the landlord.
Yes, your lordship.
Are you filing a affidavit?
Private state has no role.
You for when you file affidavit?
3 weeks time may be given, your lordship.
MS Yaoswai, no?
Yaosai, your lordship.
Yaoswai, sorry.
Yes, your
So the pen behalf of 2 today and praise the Shmil out. 2 weeks time to file affidavit.
Yes, your lordship.
Just thereafter. The praise allowed this on soon.
13.
Yes.
This is a case where I was awarded the contract and I completed the work, submitted my final bill way back in 2013. And I also registered under the GST.
No, see the last order.
Yes.
You didn't go and meet them.
We went and met the
So what happened?
And at that office, they said they are going to withdraw the letter of recovery. But till date, they have not issued. When we again inquired, they said that file has been put up, but no order has been passed. But only problem, they said they are going to cancel that order of recovery, and they will settle the final bill. They will do that. But meanwhile, my lord, till
this is what they told me the last time, my lord. It appears that there is some misunderstanding or confusion, my lord. My lord, some more time is given.
Problem is that, my lord,
it will be resolved, my lord.
till they have not issued any order for cancelling. And meanwhile, one of my bill which is pending in GE Mohanbari, they have issued a letter that they are going to recover in view of that circular. They are going to recover from my pending bill. So, till any step is taken, my lord, I simply...
No, but then that orders, there are no course of steps taken against you.
But it is only till today, my lord.
Okay, we will extend it. Dr. N. Mozika submits that the process of consideration is still undergoing. He prays that the matter be released after 3 weeks for him to await any outcome. Stop. In the meanwhile, till next date fix, next para. In the meantime, it's ordered till next date fix. No course of action will be taken against the petitioner towards any recovery. Just after 3 weeks.
But by any of the GE, my lord, if
Yes.
that is added.
What team?
Who's for the respondent?
This is this transfer matter.
My lord,
have you recalled order?
My lord, on the last occasion, my lord, when the matter came up, my lord, we were not aware about the facts and circumstances, my lord, under which the transfer order was issued. Even the petitioner, my lord, did not explain much in their petition as regard to the as to why the transfer order was issued, my lord.
So you can't just give a bunch of papers.
No, my lord, this is...
Unless I know, unless an affidavit
my
is
lord,
filed, my lord, how can I answer?
I will just...
because
point
I relied on the impine order. Impine want to say public interest.
Only my submission, my lord, can be recorded. Now, my lord, as far as this present transfer order is concerned, my lord, the reason why it was issued is, my lord, there were multiple of complaints, my lord, which were received against the petitioner, my lord. These complaints were from the teachers as well as...
That's what I'm saying. That's what the school is saying. Pick up department proceedings
yes,
if there are complaints.
Yes, my lord, I only my small submission, my lord. Various complaints were received from the teachers as well as from the parents, my lord.
Okay.
51 number of teachers, my lord, they filed complaint against the petitioner.
51 teachers?
51 teachers.
How many, what's the strength of the teachers?
My lord,
What's
I
teachers'
could
strength
see
there?
from the record. 51, my lord, they have filed complaints, as well as 438 parents, my lord, they have signed, they have filed complaints. My lord, can kindly see the seriousness of the situation. And therefore, my lord, the government, after seeing the seriousness, my lord, has constituted a committee, my lord, departmental inquiry committee, to inquire into the matter, my lord. And thereafter, my lord, inquiry was conducted. Even the petitioner, my lord, was called upon to explain the allegations. Thereafter, my lord, various things, my lord, which has come up. If my lord can have a look at the inquiry report.
What you're saying?
Now, as far as this
it's not on the record as yet, yes.
Yes. As far as the report, my lord, which I could see, it says, my lord, various allegations of misappropriation of fund, then mismanagement of the school, abuse of children in some cases, my lord, and illegal appointments of casual staff, then appointment of casual staff for their personal use, then, my lord, illegal appointment made by disregarding the recommendation of the district selection committee, then various other, my lord, allegations were there, which was inquiry was conducted, and thereafter, my lord, the committee has given a recommendation in the inquiry report that she be removed immediately. She be removed immediately from the post of principal, and as a consequence, my lord, she was removed and transferred to the present posting, my lord.
See, that doesn't make any sense, because like, what is the normal course in matters like this for if you appoint for this authority to do is that if there's a delinquent employee who's not discharging the duties properly,
yes,
are we abusing the office of which they're occupying? The course that you drop DP and you pull it on suspension,
yes,
then what is the question of transfer? I mean, transfer is like a form of punishment without them being given a chances to show cause against, whether there's any contemplated disciplinary proceedings.
My lord,
There has to be, there's always a way,
yes,
but then the way should be, clear, yes, how you approach it. You can't just, a person's going to retire in just a month.
Yes, that is what,
and then
my lord,
just in a month he's going to retire, you don't give any reasons, you just transfer.
My lord, on the last occasion, the court...
Now this court wants to know whether I contemplating drawing up any department proceeding against her.
My lord, that may be in the process, my lord.
Maybe we don't want.
Yes. But in the meantime, my lord, why this transfer order should not be interfered with, my lord? Because as per the report of the inquiry committee, my lord, now there are things, my lord, which has come up as regard to the operation of the bank account single-handedly.
That's what the court is saying. If those are serious matters, yes, transfer will not cure it. You're not transferring a problem or something. Yes. You don't transfer a problem, you try to cure it.
Now, only submission is, my lord, that if suppose the petitioner is allowed to continue in the same post, my lord.
See, it comes back to the same thing. What is the action you going to take as an authority?
My lord, as far as actions which will be taken by the government, my lord, that is not yet taken as on today. But as far as this transfer order is concerned, my lord, why this should not be interfered with, my lord, is because
grounds you're making out now by bringing some materials.
Yes.
Those grounds are for a different type of proceeding, not for transfer. Is this a penal form of transfer?
My lord, as per the inquiry committee report, my lord, the recommendation was given.
Forget inquiry committee report.
Yes. My lord.
Inquiry committee will go whether they will say that whether maybe department proceeding is called for or not, warranted or not.
Yes.
That's all.
My lord, she has been transferred within the same district.
Forget about same district. We're not bothered. We are bothered about your decision-making process, how you come to arrive at the transfer order. And the reasons that you're showing is because of lot of infractions and defalcation and dereliction of duty.
Yes.
So what are those?
That has come up during the inquiry.
But transfer order was occasioned because of your inquiry, correct?
That is one way through, my lord.
You have all ammunition at your disposal.
If you go through the inquiry,
but if looking at it, suppose look at it from other side.
Yes.
A person you allowed to serve in 2014 in a post.
Yes.
2014.
Yes.
Now it's going to be 9 years.
23.
It's 9 years. 9 years now a person one post. He never transferred her once also. At the fag end of her career, 1 month left. You transfer and then you see these are the...
Yes, my lord. Even the court was very much surprised because the transfer order was issued just before a month. Even yes, myself also, my lord, I was a bit surprised. But after, my lord, I have the instruction.
You have recourse to other remedy, which could not say. Show the recourse. You have considered the department inquiry since 1st September 22. And you transfer her 1 month for retirement. Whatever be the conduct, Mr. Sinkhan, the only thing that's the difficulty. You're looking at law, we're not looking at circumstances here. What does the British have to say?
Lordship.
It seems very
My lord.
serious.
No, my lord. No, Lordship will not go into that. Lordship will read the impugn order, my lord. What is the impugn order? Impugn order categorically say in public interest, my lord. There is a settled position of law. A transfer order, my lord, normally cannot be challenged because this is a condition of service. So for public interest, it can be transferred. But now what my learned friend is discussing for the first time, which is not mentioned in the impugn order, that there are some pending proceeding, etc., which is not even reflected in this impugn order. But can it be done, my lord? Public interest, yes, it can be done.
To the council, there's no proceeding pending also.
Lordship, nothing. And he has filed a bunch of papers before your lordship without filing an affidavit, without giving me a copy. Lordship, I'll take my lord again to that impugn order. Lordship will kindly, my lord, for the sake of my lord appreciating the facts, your lordship will come to page 19, my lord, of my writ petition. What it say? It starts, my lord, 9 June 2023. It was served to me sometime on 12th, your lordship. It's in the interest of public service. Nothing else, your lordship. Now, law has been categorically settled and transfer order, which is a condition of service, cannot be challenged, my lord, unless it is mala fide. Now, my lord, my landed fry bringing this bunch of paper, your lordship, now he is admitting, my lord, this has been done with a mala fide intention. If it is not mala fide, what else is mala fide, my lord? He's saying public interest, now he's saying, no, there are a lot of allegations against. No, I have not been show caused. I have not been given a chance.
Petitioner was part of the inquiry, my lord.
See, Mr. Khan, that's not a defense. You can be part of an inquiry. You know, actually, see, you think as a practical person.
Does he want to say he has punished me by sending a transfer? Transfer can be by your punishment.
It's coming to that.
If my lord
that's why this court asking whether this is a penal transfer.
If my lord will see the transfer order, my lord, it nowhere says that it is a penal transfer.
It nowhere says now by bringing your facts on record.
That is one aspect of the matter, my lord. That is one.
It's not one aspect. It's the entire sum and substance, the bones and the flesh of the entire matter that occasion the transfer order.
Yes. If otherwise also.
Sorry, my lord, I forgot to bring that decision very clear. Whenever court examine an administrative order, whatever is cited in the administrative order, court will confine. Any other documents, my lord, even in the affidavit, should be ignored, your lordship. This is the way of writing a transfer order. Saying public interest, now he is coming up with a bunch of paper making all reckless, careless allegations.
Only fear is that, my lord. If suppose he is allowed to continue in the same.
You have other recourse. How many times the court? I'm not going to say what recourse you have then.
Regular transfer, if my lord will say.
Regular transfer.
Now,
the very submissions that you made, Mr. Sinkhan, show that it is not regular transfer. She cannot be allowed to remain in the office because she has defalcated money, misappropriated funds. She has misbehaved with the students. She has 101 complaints against her.
Yes.
Then
that is what has come out from the inquiry, my lord. Yes.
So what next? If she is, it's pointless.
My lord, I have not seen, he has not filed an affidavit. He can file. Lordship will not go into this thing. I have not seen these things.
Mr. N. Sinkhan, Leonard, government advocate, today has produced some records to try and substantiate the reason for the transfer. Stop. As per the submissions made, the transfer was occasioned due to the what should be recorded.
My lord, because I have not seen, my lord, he has not served me a copy. Let him file an affidavit. Let him file an affidavit, my lord. And these are not the reason for filing, passing this impugn order.
Anyway, Philip Schweiron. Yes. Irregularities. Alleged irregularities that have been committed by the petitioner. Subject paragraph. Mr. S. and the petitioner, however, vehemently objects and submits that There's no proceeding pending against the petitioner, nor has these said allegations been made known. So, next, in this view, the matter, the response directed to file an affidavit in opposition within when?
Within a week's time.
Within 1 week. This thereafter, interim order passes will continue until that happens.
Well, the interim order will continue.
Yes.
Obliged.
Till next day.
Hearing. Item 15.
Well, item 15 and item 18, these are connected matter, same matter. And it is covered case, Your Lordship.
No, not covered. Only submission that Dr. Moske has made, say, please keep this matter pending because we file SLP. No submissions on law anymore.
Lordship order dated 2/11/2022. Lordship order.
No. 2/11?
2/11/2022.
No, we're not looking at that. We're looking at order dated 10/5. He said that fine, he has no quarrel that the judgment will not cover Havildar clerk. Only thing is that since SLP has been filed, can the court to wait.
Benefit of extension of the judgment I am seeking for, that has already been attained finality after they have tested that judgment before the Supreme Court. SLP number also in para 9 I have stated, and that has been implemented. That has been implemented out of the 16 or 18 technical categories, my lord. Thereafter, all the technical categories came up before this court, and Your Lordship passed judgment. Division bench upheld that judgment, and division bench further says, my lord, that all similarly situated should also be granted the same benefit. That was upheld, and they have, my lord, Chauhan case went to Supreme Court. They have challenged.
Now I believe other connected cases that are there regarding this particular thing, that the Supreme Court asked for all the orders, correct? Pass on all the matters.
No, that's what we are asking for. That the extension of the benefit of a single bench judgment already tested in the Supreme Court.
Delay has been condoned, my lord, in SLP. Notice has been issued to the respondents, my lord. Mr. Chanda is representing many of them, my lord. And moreover, my lord, the Honorable Supreme Court has asked for all the orders. All the orders.
That was what you made aware last time. Let's wait for 2 weeks or 3 weeks. Let the Supreme Court open, because if things are as they are, no problem. There's no question you won't be covered.
They have implemented, my lord.
Not to
speak of cover. They have already implemented in respect of my lord, operator radio line.
Yes,
they have already implemented.
They have implemented in other trades because
and they have tested that case before the Supreme Court.
Yes,
they have tested this case before the Supreme Court
because the contempts were pending, my lord. So we had
that cannot be a ground, my lord. Contempt were pending. That cannot be a ground.
Simply SLP was dismissed, my lord. The Supreme Court did not go into the merit of those matters, my lord.
Because they tested that case.
Mr. Chanda, this is like an old football we're kicking around all the time. These matters.
And on the other day,
my
lord,
the football now lost its color, is become brown.
My lord, on the other day, His Lordship Justice Dingdo also passed judgment in favor of the similar prayer, my lord.
And that's gone on appeal.
No, recently, very recently.
That's ordered by the not single judge, my lord. We are in the process of filing an appeal against that.
That was produced before the division bench. I was a party to it.
That was this was not, they have not preferred any appeal.
In Mr. Debnath's case.
It is in the process of filing.
Prem Singh? No.
No, my lord.
So it is Binil Kumar and Shaitapal.
Now, even the other matter, your lordships, was in the division bench, my lord. That is also in the process.
Lordship may look into para.
No, this. You're aware. See, Mr. Chanda, let us wait, just let the Supreme Court open. Then we can finish it off. You waited for so long, 19 till now. Conveniently, let's hope we all get this.
My lord, I don't think there's 23 or 24 it will be over.
No.
23 or 24 it will be over. I don't.
We just said after 1 day we'll finish it off because there's nothing left to decide this matter. As things stand, there's nothing left to decide.
Division bench rather observed that 6% interest to be paid.
That's beside the point. There's nothing left to decide. Any other trade will become, any other trade that comes will be covered.
But everybody will become officer, my lord, in Assam Rifles. If all these orders are implemented, this is creating a chaos in the hierarchy, my lord. All are becoming officers, my lord. But the Jawan, they remain Jawan, my lord. The actual fight is, my lord.
That doesn't matter. That is because of the latches on your part.
Yes.
Memorandum said something else. You went and extended to all the trades, to other
We
trades.
didn't extend, my lord. Mr. Chanda was
Instrumental.
instrumental in this one. Right from
They have tested everywhere, my lord. Division bench, Supreme Court. Thereafter, they have implemented all these judgments. They have tested.
No, they had no choice. They had to implement it.
And here in the other case, my friend was there. This case.
Which
my
friend?
friend was there.
But the final word will be set, most probably in this case, my lord.
The final word
In
already
SLP,
told.
my lord.
Already.
After that, my lord, if we have to implement, we will have to implement.
No, that judgment 24/2022. This was covered. Yeah, 24/2022. Correct, Mr. Chanda?
My lord?
Division bench 24/2022.
Yes, my lord. 22, my lord.
22, that judgment 24/2022. I think. It'll cover your case.
24 yes.
24/2022.
24/2022.
Yes.
24.
24/2022.
Yes, my lord.
Yes.
Yes.
Yes, in a batch of 18 matters, my lord. Common order will first.
That I have given, my lord, a list of judgments. I have given.
Not here.
On the last occasion, your lordship.
Yes, you can take it back, this Satyapal.
Oh, my lord, yes, they are, my lord. They are in the bunch, that bunch, page 36. That bunch, page 36.
Yes.
Para 3, para 10, 15, 21 and 20.
So it goes back to the judgment of 2011. At the judgment 2011 attained finality that time.
Yes.
Like that.
Yes.
I think these series of matters are the most matters have been chewed on in this.
Yes.
By Manipur High Court, Guwahati High Court, Meghalaya High Court.
But the other issue remains, my lord, they are referring to or relying on orders passed in 2010, 2011, 12, my lord. My lord. As if it is a perennial source, they can come anytime, my lord, and take a dive in this.
That you have argued before the division bench also.
No, others haven't come and taken a
Yeah,
dive.
Bagu.
Now the new matters are coming. So others who were totally out, they were dismissed. But some in Guwahati High Court, some judgment came which was in their favor, which is not, which was dismissed here, but allowed in another High Court involving similar circumstances. So they're coming with a petition and they're taking a dive into that also to take the cover of the judgment.
No, regarding not
Because it's gone to
in this
Supreme
issue,
Court or
my lord.
something.
Not in this issue.
Not in this.
Not in this issue. Page 38.
No, it's okay. It's okay, Mr. Chanda. You don't have to show anything. You're aware of the judgment, this last year judgment. But we'll wait in July. We'll pass final orders in July only.
My lord,
They're given us satisfaction.
Second, after 2 weeks, my lord. After 2 weeks.
2 weeks, nothing. Shumko is not open. Nothing will happen.
First week of August, my lord.
Though these judgments, though the matter is substantially covered by the judgment rendered by coordinate benches and by the division bench of this High Court, on submission of Dr. M. Bozika, that the matter is now seized before the Supreme Court, which is closed. This is a matter up to 4 weeks. We'll dispose of next date.
I'm very much hard pressed, your lordship.
Every time we hard press, Mr. Chanda, all lawyers are hard pressed. And to dispose of, there's nothing. We'll just require 1-page order. Just better.
20.
Only, my lord, because they can test, even if those cases are, they can go to the division bench, your lordship. That liberty is there.
18.
18 also is connected.
20.
Yes, second appeal. Yes, Mr. Appeal.
As per the last order,
There will be one
substantial questions of law.
Have they been retyped? Retyped, ne?
No.
Is that retyped and consolidated sheet?
No, not yet.
No, but what I had to ask for typing consolidated sheet. No, because yes, we said
Because
that.
they have
Question four that
suggested-
we gone. 1, 3, 4, 5, and 6 by the appellant, and question 1, 2, and 3 by the respondents. Should we do that first, or what should we do? It's not because we have to pass orders on
Yes.
issues.
It's better to be done. Otherwise, also, Miller, today actually, Miller, I would have taken your lordship through the history of the thing and the factual aspects of it. And then, Miller, of course, on the legal aspect, I don't think it will be possible today, Miller. So, this, I feel that it will take a little time, the whole thing.
Doesn't matter. Second appeal is
Second
enjoyable also.
Second
You know, like in a way, boring for many. Yes. Learned Senior Counsels for the party submit that the questions of questions of law have been framed as indicated in the respective as indicated in the order dated 5/5/2023. However, consolidated list is yet to be is not available in stock. Accordingly, the substantial questions number 1, 3, 4, 5, and 6 submitted by the appellant, and the questions number 1, 2, and 3 by the respondents to be typed in a common list and a common list for and common list of issues to be taken by this court. When should we list it then?
Well, I would just only submit that whenever your
Leaving
lordship
the-
has a little.
No, we have time. We always out of station, Mr. Chakravarti. Because of your personal commitments.
Well, I'll ensure that I'll be here. Let me convey to as per convenience of your lordship. I'll be ensure I'm here.
2 weeks time will get it. Yes, this matter up to 2 weeks. So one chance to put me. One time. Come down. Consider list.
Supply.
Can you consider list?
We can supply again.
No, it's there. Anyway, stop. We'll do it. Yes.
21.
Yes. Yes, start.
Let it come after 2 weeks later. Item 21 and
This is what matter is this?
This is regarding Pascal, Your Lordship.
Who's for the other side?
Mr. Mujika is there.
Devnath?
Mujika. Dr. Mujika is there.
Mr. M. Where Mr. Devnath? Mr. M. Chanda pays for accommodation. Accordingly, this is matter after 2 weeks.
Item 24 also, my lord.
24.
24 is again covered matter. 24, 25, 26.
Is that what? Compulsory retirement?
No, well.
May I be lordship? 1 second, 24.
25.
25 is your matter?
Yes, 25, 26 and 28 are connected matter.
Yes.
It is squarely covered by the division bench order, my lord.
What's issued order?
My lord, I'll let it come after 2 weeks.
No, 24 come to 2 weeks. This is another matter.
No, these are all similar
Connected.
matters.
You are there, Mr. Chanda, 25.
At 24 I am there.
No, no, this is 25.
25 is also
24,
connected.
25, 26 and 27 are connected matters.
Connected matters.
Yes, Mr. Kumar, what do you have to say? Yes.
My lord, this matter is connected to the item number 24, my lord. So this matter will be taken after 2 weeks, my lord.
No, no, we'll dispose it of 25, 26, 27.
25, 26 and 28, my lord.
25, 26 and
28, my lord.
1 second.
My lord, I will try to make a distinction between the judgment passed by the division bench. So these 3 matters are also may be taken up after 2 weeks, my lord, along with the item 24.
Here actually what happened, my lord? I was just in brief, my lord.
Yes.
The petitioners were appointed as recruit clerk, my lord.
As recruit clerk.
Clerk, my lord. And they were required to pass certain examination for that purpose for absorption, my lord. Now there are hundreds of them were recruited like that, my lord. Some of them, these petitioners, they could not qualify in the test, my lord. The test that was taken for stenography, my lord. So they were given on humanitarian consideration that you will be allowed to, if you opt, you can continue in the GD duty, my lord. So that's how they came back to GD, my lord. And they are serving for almost 30 years in GD cadre, my lord. They have a well promotion in that channel of promotion, my lord. Now, because the clerk cadre has been given certain benefit by this honorable court, my lord, they came before this honorable court saying that we are also initially recruited as clerk, and so we should be given the benefit of 1997 that clerk's pay scale and all that. The learned single judge allowed that, my lord. In division bench very clearly said that once you have opted and you have held the channel of promotion in the GD cadre, now you cannot go back and claim something which what happened.
You're ready to matter today, Mr. Chanda?
No, because 3 cases I prepared. Last 2 cases I have not prepared, my lord. Let it come after 2 weeks, your lordship, I will argue that matter.
Well, let's come to 2 weeks. Item 24, accommodation 20, no, the 24, take it after 2 weeks stop. Next for this next item, 25.
And 28.
Mr. V. Kumar, Land Council petitioner, submits that as the matter in sum and substance is similar to item number 24. He prays that the matter be listed together after 2 weeks. Yes. Same order in 25, 25, 26, 28.
Obliged.
To try to distinguish, otherwise we'll dispose it of.
My lord.
27.
Subsequently, some judgment has come.
Yes.
Subsequently, some judgment has come.
27.
My lord, in item number 27, my lord, the similar play of this matter may be taken after 2 weeks, my lord. Because due to the water logging, my lord, we could not collect our file from chamber, my lord.
Oh, due to water logging. At least the matter on after 2 weeks as the due to personal difficulty of the counsel for the petition. Yes.
My lord, take your lordship.
29.
What happened, Dr. Mozika? What about the validity of the first advertisement?
My instruction is that there is nothing in the rules, my lord, for how long the first advertisement was valid.
No, but they reverted back to that by your action.
Yes.
How do we rationalize the whole thing? We have to show the court. stuck on that point only. There has to be some definite kind of instructions, Dr. Majika. We are just waiting for that. Because see, where's that part where he said there, the first advertisement that those who applied for the initial advertisement need not apply again? Where's that, Mr. Patel?
It is in the advertisement itself, my lord.
Where is it? Yes, kindly show it. After an opposition, page 10. Right.
My lord. Yes, my lord. Yes, this is 2007 advertisement and subsequent, my lord.
See, the last candidates have already applied to the post mentioned at 1 to 6 as earlier advertisement need not apply again. The applicant will receive in this institute considered provided applicants have been made when the applicants have been made eligible. So what happened to reduce the quota?
My lord.
I forgot. What happened?
My lord, what had happened? My lord, in the second advertisement which had come out, my lord, in 2017, there were, my lord, two categories. In two for the UR, that means unreserved, my lord, and two for the ST quota, my lord. But in the earlier advertisement, my lord, there were 4 for the UR, that is unreserved category, and 2 for the ST, my lord. So they reduced that by 2. Subsequently, my lord, they issued a corrigendum that there is a mistake. So, my lord, that mistake was corrected. So it was brought back to 4, my lord, in the unreserved
4
category.
for UR, yes.
Yes. Then thereafter the result was declared, my lord.
Then?
And in the result, of course, I have qualified, my lord. I was there in the list.
Your number?
I was number 4 in the list, my lord.
Okay.
4 posts for the UR, so I was the 4th candidate, my lord.
Yes.
Then subsequently, my lord, they issued another letter cancelling that corrigendum. And against that, I am agree, my lord. Process honorable court. In fact, my lord, on even corrigendum itself, there are a lot of honorable Supreme Court judgments, my lord. What is the nature of the corrigendum?
Now what happened? He said one resign.
My lord, one resign. So subsequently, my lord, when that when the corrigendum was cancelled,
yes,
after everything is prepared, select list, everything is prepared, suddenly that corrigendum is cancelled. Then they've come out with a new list, my lord. Now in that new list, I am in the waiting list. Waiting list candidate, my lord. There are 2 candidates who got selected, and 2 were, that means 3rd and 4th in the original list, they were put in the waiting list.
You were number 4.
I was
number 2 in
4.
waiting list.
Yes.
Yes.
Now even in that vacant list, my lord, one of the that is a person above me has already joined the railway, and my lord, the one of the candidates who was selected who joined the service also left service, my lord. That
But
was
you
number
can't,
1.
that the law does not allow you to be appointed against.
No, my lord, but there is specific DOPT instruction, my lord,
Yeah.
that how the post is to be filled up. A guideline is there.
Where's the
And to my
guideline?
understanding, my lord, Negrims is following that guideline, my lord. My lord, this is one of the guidelines. My lord. But my case is that, my lord, the corrigendum could not have been cancelled. That's the first case. my service should have been considered in the first instance, because that rejection itself was arbitrary, my lord. Now here, my lord, if I may refer to para 2, my lord.
Yes.
The fifth DOPT guideline. I'll give you one copy. The fifth Central Pay Commission in para 17.11 of its report has recommended that with a view to reduce delay in filling of the post, vacancies resulting from resignation or death of an incumbent within 1 year of his appointment should be filled immediately by the candidate from the reserve panel.
Which department is this, Mr. Dr. Mazika? Nigrims?
Yes.
Why did you accommodate him? If the post is vacant now?
Their contention, my lord, vacancy arising out of resignation, my lord.
No, my first contention is that, my lord, the corrigendum itself.
No, it's not a normal. See, normal course you can understand if, like, if you can understand if, there's a list, vacant, like there's a selection process has been duly held, waiting list is made, the person's joined, then one person doesn't join, fine. He joins, he resigns, then that vacancy created is a fresh vacancy. Then it has to be a fresh selection process again to re-advertise. But in this case, what has happened is that you, by one advertisement, you said this number of posts that are there. Then you don't kill that old advertisement, you let it survive, and then you issue a corrigendum saying, okay, fine, the posts have been reduced. But then now you resign, you have a vacant post. Why can't you be accommodated? This is not a run of the mill, it's not a normal case.
But actually, the difficulty lies in the fact, my lord, that the ministry is instructed that
this is the ministry guideline, my lord.
2 posts which are there, my lord, should be advertised afresh. And my humble submission, he can apply the post to your advertisement.
My lord, this is very clear. My lord, if I refer to the next line, my lord, such a vacancy should not be treated as a fresh vacancy. This is a clear minister guideline from the DOPT, my lord.
Where is that document to show that they've directed you to re-advertise those 2 posts?
They have taken the sanction from the central government, my lord, for 6 posts. The sanction is already given. Only thereafter the advertisement came into existence. Selection process was carried out to fill up these posts, my lord. Now suddenly, arbitrarily, can it be reduced? Corrigendum was issued. They was assuming that there was a mistake in the second advertisement, realizing that because they referred to the 2007 advertisement, then they realized the vacancy was 4 plus 2. Immediately they issued a corrigendum saying that.
Page 81 of the affidavit.
Oh yeah, affidavit. Eighteen. 81.
This was issued by Negrims.
When was this issued?
This is of 21st April 22. After detailed discussion, the fourth paragraph, third paragraph.
81.
Page 81.
This is a letter issued by Negrims, Annexure 13.
Why? What detailed discussion was there?
But actually, what happened, if I may just state the facts, my lord. My lord, 2007, the original advertisement.
6 posts.
6 posts, my lord. Advertisement remained pending. Well, I've given a list of dates, my lord.
Yes.
The 7 to 17, the advertisement remains pending, my lord. In 2017, second advertisement for filling up interview, 4 posts of sanitary inspectors was issued. Advertisement further stipulated that candidates who have already applied against the earlier advertisement need not apply again, and that the earlier application receipt will also be considered. 67 eligible candidates from 2007 advertisement were considered eligible. 103 applications were considered eligible from 2017 advertisement. Written test was conducted. 23 candidates appeared for the written test. After this, my lord, on 2/8/21, a corrigendum was issued stating that due to error oversight, the number of vacancies for the post of sanitary inspector as advertised may be read as 6. Unreserved 4 posts and ST2 posts instead of 4. And 25/11/21, recommended candidates list was published in 3 categories. Results were also declared. Now the merit list was published and the following candidates were provisionally selected. No appointment orders were issued. Now this was placed before the selection committee meeting held on 21/4/22. Decided to limit the number of.
No, that's what. Can he do this decision?
Cannot, my lord.
But the reason being, my lord, the corrigendum that was issued, that was without any proper consideration.
My lord, the corrigendum is.
No, wait, let him finish.
Now then the selection committee decision was forwarded to Ministry of Health by letter dated 19/5/22. Director Negrims is the appointing authority for Group C and D, hence Director may take appropriate action as per the recommendation of the selection committee. Then 2/6/22, corrigendum dated stands cancelled as per the decision of the selection committee, and the number of posts of sanitary inspector will remain as 4 as advertised by advertisement so and so. First merit list was on 2/6/22. It was valid for 1 year. Now 16/6/22, all 4 selected candidates were appointed. Appointee Sri Deepak Kumar, after joining the post, resigned from service on 27/4/23. As per the submission of the petitioner, the waitlisted candidate number 1, Rahul Chakravarti, is not interested in the post anymore. We don't have any official information to this effect, my lord, but this is what the petitioner is saying, my lord. Our case is that vacancies arisen after all selected candidates were appointed. With appointment of all the selected candidates and filling of all the 4 to the select list has served its purpose and expired. Vacancy arising by resignation of a selected candidate cannot be filled up by a waitlisted candidate.
Where authority? You got any authority? You brought anything?
My lord, of course, today I could not
Why?
take the printout, my lord. But however, my lord will kindly see.
No, we have kindly looked at everything also.
No, my lord, one.
Look, see, we're trying to help you. At least you bring authority with regard to corrigendum and cancellation and effect. And advertisement, the advertisement, the base is advertisement.
Yes. My lord, another aspect, if I may humbly submit, my lord. My lord, once a merit list is out, my lord, selection committee sits over it, a merit list is out, my lord. Subsequently, my lord, can the selection committee again revisit that, my lord? Once the select list is out, first select list is out, the business is over, my lord. Can the selection committee resit over it, my lord? They cannot. My lord, the first result is out on 25th November 2021. That is at,
no, this amounts to real arbitrary action apart of the director. Because whom is the whatever Ministry of Health said, you look at it. You dispose it off.
The direction to consider, my
lord.
We can't ask
He should get appointment. As far as authorities is concerned, my lord, of course today I don't have it. If it comes up any day, my lord.
Tomorrow.
My lord, this week only some difficulty because my son is having exam, my lord. So
you have to sit the exam with him?
No, my lord, odd hours I have to pick up and all that.
But we
if
heard
it comes
that
up next Monday or Tuesday, my
your
lord.
son is brilliant. So
if it is taken up next Monday or Tuesday, my lord.
It is when,
or it can come up on Friday also, my lord.
Friday, okay. Bring authorities. Yes. Other-